Good afternoon, everyone. I am indeed Ken Adams, and I'm here to tell you that traditional contract drafting is the worst. Actually, let me try that again. That traditional contract drafting is the worst. Am I in the company of people who, are transactional types? Raise your hands if you, wave your hands in the air if you're a transactional type. Yep, I would have expected as much. We're going to spend the hour considering what I mean when I say traditional contract language is the worst. We'll consider why we care about that, what explains it, and what we can do about it. But it might make sense to start off by considering why I'm the guy up here talking about this enthralling topic. Well, essentially, I've spent a large part of the last 20 years immersed in contract language, figuring out the building blocks of contract language. Apparently, I have some combination of aptitudes and interests that makes that not entirely irrational occupation. But perhaps another reason why I'm up here is that I showed up. It turns out that no one else is interested in this subject to the extent I am, so I'm kind of the last guy standing. But a little warning before we proceed. I have an unfortunate habit of latching on to lame online memes to make some points. My daughter mocks me relentlessly, making me feel somewhat like this guy, but I persist nonetheless. If traditional contract language is the worst, it's because of the dysfunction that's inherent in traditional contract language. So that's something I have devoted hundreds of pages to in my book, A Manual Style for Contract Drafting. So it's very easy to get immediately swallowed by the detail. We're going to do our best not to have that happen. We're going to just dip our toes into the subject by considering, first off, the dysfunction in the building blocks, the words and phrases used to say whatever it is you want to say in a contract. We're going to look at three little doses of that dysfunction in what I call the front and back of the contract, the categories of contract language, and selected usages. So the action in a contract is in the body of the contract, namely that which the parties are agreeing to. But there's stuff you have to put before and stuff you have to put after. It's not where the action is, but you can sure clutter things up if you have the urge to. So this, on this slide, is an extract from a random contract I selected. It represents the traditional approach, and we'll consider what we have here. Well, here's the introductory clause. Made and entered into. Welcome to the world of redundancy. First, we made the contract, then we entered into it. I just say is dated. How about the 15th day of January? It makes that seem like a very special day indeed. A day that will live in infamy. But the sad fact is that we have a job to do. We have information to convey. We're not trying to memorialize something or, make it seem extra special. So let's just say January 15. And a corporation organized pursuant to the laws of the state of New York? I think we can just say a New York corporation. But perhaps the part of this that I find most amusing is at the front of the introductory clause. This consulting agreement. Lawyers like giving initial capitals to stuff that's important, and nothing's more important than this consulting agreement. So we're going to give it initial capitals. But actually, if we say this consulting agreement is dated, we're just referring to a thing. So consulting agreement is no more deserving of initial capitals than the word car in this car is fast. So I'm going to use lowercase letters. Then we have this, which creates the defined term, this agreement. A defined term is a label you use for a broader concept so that you can state the concept more concisely and consistently than you would otherwise. But what is the broader concept underlying this agreement? It's this agreement. There is no broader concept. So I take the revolutionary step of striking that. And I just say this consulting agreement, lowercase letters. Elsewhere in the contract, I say this agreement, small a. If some of you are prone to fainting or are feeling kind of a hot, kind of palpitations, please consult the Clio medical staff. We can talk during the question and answer session perhaps about how I managed to get these insane notions across to other people. But at the moment, for now, we'll just think about what makes sense, and this agreement as the defined term doesn't make sense. I'm not suggesting that this is somehow important for the deal, but what the heck? If you get rid of unnecessary initial capitals, get rid of an unnecessary defined term, you're eliminating clutter, you're eliminating that which makes the contract harder to read. So it's a plus. But furthermore, I like to highlight this simply because it's an indication of an approach to contract language. You're not doing that because it makes sense. You're doing it because it has been handed down by the ancient ones. Yours is not to reason why. Yours is to copy and paste. So you can be sure. I just know when I see this stuff, it's just I know that the body of the contract, where it really matters, it's going to reflect that same deferential approach. So it has a kind of canary in a coal mine value. So, well, how about the rest of the front of the contract? Oh, witnesseth. Well, witnesseth? I can't even. It looks like you're saying, oyez, or now hear this, but in fact what you're saying is abandon all hope for clear drafting, all ye who enter. The drafter is essentially saying, I am a robot slave to precedent. Whereas is a perfectly good English word, but not to convey that meaning, which is archaic. And the archaic trio is rounded out by now, therefore. All this all-capital stuff is just saying, I'm an archaism, please put me out of my misery. It's a relic of drafting tics from 300 years ago. We have a job to do, we have transactions to express, and it's ridiculous that we populate our contracts with this sort of debris. I find it's unfortunate to have companies at the cutting edge of their industries who have contracts that look like they've been kicking around for a couple of hundred years. I'd like to have contracts be as cutting edge and as effective as the companies that they serve. And how about this stuff? I suspect this is in all your contracts. Why is it in your contracts? Well, for my contract to be enforceable, I have to get something in exchange. That something in exchange is called consideration. So what it looks like this is trying to do is say, okay, move along. We got consideration here, nothing to see. Keep on moving. But it's a basic fact of black letter contract law that you cannot create consideration where there was none just by saying you have consideration. So to cut a long story short, this is effectively useless. If you have a consideration issue, you'd much better address it head on rather than putting this in and hoping somehow for the best. It's a kind of feature of my life that I have to write about stuff, then I write about it again, and then I keep writing about it. But I'm happy to say I think I've written earlier this year I published my final article on the traditional recital of consideration. It's kind of game over, case closed. It is so preposterously ridiculous. You can read also on my blog about the phrase valuable consideration that is so irrelevant at many levels. Nevertheless, good and valuable and receipt and sufficiency, preposterous stuff. It lives on through the magic of copy and paste. So what do? Hey, here's an example of my introductory clause. MSCD is the initials from my book. Here's an example of my approach for recitals. I'm sorry it's not more glam. Sorry that it's not more, majestic or somehow, but I just do what I have to do. In the recitals, I tell the reader whatever they need to do, they need to know in simple narrative prose before they leap into the body of the contract. And the lead-in, the parties therefore agree as follows. Categories of contract language. Now, I devote many pages and endless hours to this topic. We'll just dip into it. The idea is categories of contract language is the phrase I use to describe a framework of different semantic functions of contract language and the verb structures associated with the categories expressing those semantic functions. So here are all the different categories. We're going to just look at a couple. Language of discretion. May is the workhorse for language of discretion. It expresses what a party is allowed to do. Simple enough. Okay. But the chapter on categories of contract language in my book has lots of tables like this, and they all function in the same way. This one relates to may. We like may, we give it 2 check marks. But what's all this other stuff? Well, that's because in traditional contract language, you don't have semantic categories with their associated verb structures. Instead, you have chaos. You have drafters with a random bag of verbs, and when they need a verb, they stick their hand in the random bag, rummage around, pull something out, go with it, whatever. With the result that you have endless variety in how you express may. Some of it isn't completely irrational. Is authorized to. I get the idea. The thing is, we're in a limited and stylized kind of writing. It's analogous to software code. So you want to find the best way to express something and stick with it. So why would I want to instead, or as an occasional alternative to may, use is authorized to? I don't. It's 3 words. No thanks. I got may. Shall have the right to? Well, among other problems, it's 5 words. Why would I want to use 5 words? No thanks. And things can get downright bizarre. Instead of the indemnified party may, how about the indemnifying party hereby grants the indemnified party the right to retain? I don't know how many extra words that is. No thanks. Now, on to language of obligation. It comes in 2 flavors. This slide pertains to language of obligation used to impose a duty on the subject of the sentence. The subject of the sentence is acme. I recommend using shall to impose a duty on the subject of the sentence. The test for this use of shall is whether you can replace it in your mind with has a duty to. That's the simple story. We could spend all day talking about what I call the shall wars. Maybe we can go to the bar and I'll spend hours regaling you about that. But this is what we'll limit it to this for the moment. Now, a related topic, expressing conditions. To express a condition is the idea that something has to happen first before something else happens. There are 3 ways you can express any condition. So here are 3 ways of saying the same thing. The one we're interested in is language of obligation used to express a condition. How do I recommend you do that? Well, in terms of verb structure, I recommend you use must, because we're already using shall to impose the duty on the subject of the sentence. I don't want to use the same verb structure to convey a different meaning. I'm going to use must, but that's not enough by itself. You have to have something else to make it clear what's going on. So I add this phrase at the front to exercise the option acme must. It makes clear what the context is. Okay. The next block in the logic is, all right, we've seen that, but what about, let's look at shall further. We've seen shall in this sentence. Shall used to impose a duty on the subject of the sentence. Fine. But if you look at the other examples, each uses shall, everywhere shall. This slide too, hey, 2 shalls in 1 sentence. I cunningly structure the examples on these 2 slides so each uses shall in a different way. Shall is arch violator of the notion that you have one word conveying one meaning. Instead, shall is used all over the place. And that causes problems. Consider this example. Jones shall submit any dispute notice no later than 5 business days after the related invoice is delivered. It's in a contract your client has signed. Jones finds that Jones buys something from Acme. Acme sends Jones an invoice for twice the expected purchase price. Jones wants to dispute the invoice. So Jones submits a dispute notice, but after 6 business days. In a rational world, what does Acme say in response to getting a dispute notice after 6 business days, not 5? Acme is going to say, too late, sorry, no dispute mechanism for you. But what if Acme has a company policy that it's going to interpret contract language strictly no matter how irrational the consequences? And this is in the contract. It's going to look at this and say, Jones shall submit. Jones, you had an obligation to submit a dispute notice no later than 5 business days. By submitting it after 6 business days, you're in breach. We have remedies. What are we going to do? We're going to terminate the contract. We're going to sue you for damages caused by your egregious late submission of a dispute notice. Does that make any sense at all? No. The only thing that makes sense is too late. So why is this expressed the way it is? Why is it expressed as an obligation? Well, because the drafter was in a shall fog, as so many drafters are. What should the drafter have done instead? Express it as a condition. To dispute an invoice, Jones must submit a dispute notice no later than 5 business days. The distinction between conditions and obligations is crucial. It is the fuel of no end of disputes, no end of litigation. And if you're in a shall fog, as most drafters are, you're going to just blow right by it. So this sort of heedlessness is just a feature of traditional contract drafting. So here's my version. To dispute an invoice, Jones must. I can take a page of pretty much any contract and know I'll find, around 8, 10, 12 instances of verb structures that don't make sense. So, this is just one random example. We could cheerfully spend 10 minutes just discussing this one slide. Selected usages. It's kind of catch-all term. Any word or phrase that doesn't fit anywhere else in my book, it's a selected usage. So by now I have an alarming number of selected usages to talk about. But there's some real doozies among them. And efforts is one of my faves. Do you have occasion to deal with efforts provisions? Reasonable efforts, best, knowing nods. I had a look, way back in 2004, I looked at a collection of contracts for the different efforts provisions, and a whole raft of them. Best efforts, leading the pack, various flavors of reasonable efforts, hot on its heels, and so on. I keep finding new and different versions. Recently I saw reasonable, good faith, best efforts. Kind of a 3-in-1 combo package. Raises the question, what is the difference between reasonable efforts and best efforts? And the answer I generally get when speaking with people who work with contracts is that reasonable is, hey, what's reasonable? Best is, well, you have to mobilize all resources at your disposal to perform the obligation, even if it's to your detriment, even if you have to drive the company off the cliff in the process. But a funny thing happens when you look at U.S. case law. U.S. courts have said with one voice, no thanks. All efforts provisions mean the same thing, reasonable efforts. It's an amazing disconnect between courts and what people who work with contracts think, and what the courts say makes sense. Because as a matter of idiom, the phrase best efforts just means, I'll try hard, I'll do my best. But lawyers are adept at inventing distinctions that have no basis in language. And furthermore, if you're saying, you're under a best efforts obligation, it might not be good enough for you to act reasonably to comply with that obligation. You're essentially saying you might have to act unreasonably. And an obligation to act unreasonably just isn't going to work as a matter of contract law, contract interpretation. So what is the answer? Oh, and on my website you can read in thrilling articles about how courts in England and Canada have utterly gone off the rails in interpreting efforts provisions. But for our purposes, what's the fix? Relatively straightforward. Forget best efforts ever existed. Just use reasonable efforts. You can get reasonable efforts to mean whatever the heck you want it to mean. There's a whole further discussion about, okay, how can we reduce the risk inherent in even reasonable efforts as a vague provision? And there's plenty of material about that on my blog. But the main thing is just getting away from that. The negotiation theater that transactional people end up engaging in terms of, we have to insist on best efforts. Oh no, that's not possible. It's got to be reasonable. Well, how about commercially reasonable? Oh, okay. Yeah. It's all nonsense. Indemnify and hold harmless. Or how about indemnify, defend, and hold harmless? Either way, all I can say is, wow. That's because hold harmless has no established meaning. And it's a great example of the perils of redundancy. Maybe once upon a time a drafter said, indemnify, hold harmless. Which do I use? I don't know. Hey, I'm risk averse. I'll use both. And I use both, and it makes me look like a wizard. So great. But when the deal goes bad and people call their lawyers, they realize that hold harmless is smoke and mirrors. You can use it to insert unintended meaning into a contract. So it cheerfully has given rise to all sorts of litigation, with courts saying different things. Using a smoke and mirrors phrase like hold harmless is to disregard entirely the powers, the responsibilities that come with drafting and reviewing a contract. You get to say what the deal is. The idea that you use such a mystery phrase instead of saying what the deal is astonishing. Okay, indemnify has a settled meaning, so we're okay with that. It's a fancy word, but it has a settled meaning. So Acme indemnifies Wigico against what? It isn't what the verb is. It's Acme indemnifies Wigico against what? You say what the deal is. Is that you're covering out-of-pocket losses, future liabilities, just non-party claims between the parties as well. Whatever the heck it is, say what the indemnification is, rather than using what is a kind of a just dysfunctional code. And defend by itself, you're worried about indemnification procedures, and you think one word's going to do it? It's not. If you want to cover indemnification procedures, which is always a good idea, you're going to be in for about half a page of it. And there's some supplementary materials which contains a link to my blog post with my indemnification language, where with the help of readers I compiled language that addresses this sort of thing that the word defend is never going to cover. Represents and warrants. Represents and what? Basically, represents and warrants is the represents the fever pitch battle for rationality in contract language, at least in my mind. I tend to get highly worked up about represents and warrants. Is represents and warrants a feature of your contracts? Of course it is. I suspect you think you're saying, okay, we're saying facts. This is the weird phrase that is inflicted on us for purposes of saying facts. If that were the limit the extent of it, I might say, oh, okay. But there are actually commentators out there who say that no, there's a secret hidden meaning in represents and warrants. The most popular being that, it'll affect your remedies. That makes no sense for various reasons, including the fact that there's zero case law anywhere in the U.S. suggesting that, which you'd think would be just a slight impediment to that theory. So once again, hey, last year was a productive year. I also wrote definitive, after several times, my definitive article on represents and warrants, just kind of game over, case closed. It is just not only pointless and confusing, it's just even worse from the lawyer perspective. It's just dumb. So what's my alternative? Yeah, again, kind of revolutionary approach. I just say states. You want some facts? Acme states. I don't want to use mystery words and phrases that might have some occult meaning. And furthermore, I'm the drafter, I'm the reviewer. If I have remedies on my mind, which in a commercial context you don't often have, but what the heck, if you want to micromanage things, well, go right ahead, knock yourself out, and say what's on your mind. You're the drafter, you're the reviewer. You get to say what the deal is, instead of using mystery phrases. So that's building blocks, and as I say, there's hundreds of pages in which I've just gone through and parsed these building blocks with the aim of stripping out all the misconceptions and nonsense that is just endemic in traditional contract drafting. But the dysfunction also appears in the bigger pieces, the kind of entire provisions. Just a couple of examples come to mind. A couple of law school professors wrote a book about the pari passu clause in sovereign debt contracts. Not much of concern to you guys, or to me, actually, but an interesting case study, because it showed that drafters, people who worked in this area, included this pari passu clause in sovereign debt contracts without having the foggiest notion what its function was. Then it gave rise to a completely destabilizing litigation. So guess what? Well, they just kept on using it. It's just a great case study in utter obliviousness. But something closer to home is the successors and assigns provision. This agreement is binding upon and inures to the benefit of the parties and their successors and assigns. Pro tip, the word inures is a sure sign that you're dealing with complete BS. But I wrote a thrilling article about the successors and assigns provision, looking at about 8 different possible purposes that it might serve. And guess what? It served none of those purposes. So I've cheerfully thrown it on the scrap heap, but it lives on through the magic of copy and paste. So why do we care? Why do we care about the dysfunction? Well, to the extent that any given contract exhibits the standard shortcomings of traditional contract language, you're going to have delay and confusion at every step in the process. When you draft, when you review, when you negotiate, when you monitor performance, and necessarily that wastes time, that wastes money. And if an organization's templates reflect those shortcomings, you're going to have that delay and confusion spread throughout the system, conceivably wasting lots of time, lots of money. And if your competitors can be more nimble than you in handling your contracts, then it can hurt your competitiveness. Then there's the issue of someone who finds that because of some ostensible, some drafting glitch, they don't have what they expected to have under the contract. If they're unhappy enough about that, they are going to fight about it. And my book is full of tragicomic examples of people unexpectedly who find themselves in court fighting over some ostensibly minor drafting glitch that somehow metastasizes into a full-blown dispute. What explains the dysfunction? The key fact is that any given transaction is going to closely resemble other transactions that have gone before. So the urge in creating a contract for a new transaction is to base it on those other contracts. That should be a source of efficiency, but when you're in a word processing environment, you are a slave to copy and paste, which is a very inefficient and clumsy way of trying to gain the benefit of that precedent-driven nature of contract drafting. It gives rise to a pathology that I call passive drafting. What are the elements of passive drafting? Well, you don't have any guidelines. Who needs guidelines when you're copying? Just copy. You don't train anyone. Who needs training to copy? Copy. The notion of, what you copy and what I copy might be somewhat different, so we have to explain that. Well, I hear senior lawyers invoking the notion of style. Oh, you'll develop your own style over time. I have a less romantic view of such things. To express any given concept, there's going to be one most effective way of expressing that concept and a bunch of less effective ways. My drafting will benefit if I use only the most effective usages, and the contracts ecosystem as a whole will benefit if everyone uses only the most effective usages. And my book is essentially a catalog of here are the most effective usages, here are the less effective, and why. Then what you end up copying might look highly weird, so we have to have an excuse for that. There's the notion of tested contract language. The idea being that, the courts have told us what this stuff means, so if we tinker with it, we're inviting a world of risk into our lives. Sounds fine, but what a court has to say about a particular bit of contract language is going to be a function of the circumstances of the dispute and how sharp the judge is. So courts in different jurisdictions can have different things to say about the same bit of contract language, and courts in any one jurisdiction can have different things to say over time about the same bit of contract language. So if you're relying on someone to come in from outside to tell you what your contracts mean, you're going to be on very uncertain territory. And furthermore, there's something a little paradoxical about saying, this language was confusing. It gave rise to a dispute. But we're going to keep using that confusing contract language. I don't want to use confusing contract language because I don't want to fight. I'm going to express the deal in a way the parties can understand it without confusion. As I mentioned, you also have commentators out there so eager for order in the chaos that they'll invent explications that actually make no sense. And then there's the notion of, hey, contracts regulate conduct, so they have to be hyper-precise. And that's why the traditional language looks the way it does. It's hyper-precise. But when you compare the traditional language to the alternative is always clearer. What is the alternative? It's standard English, English as written by the average educated native English speaker. I make a point of not referring to plain language or plain English, because transactional types have a way of assuming that means you're dumbing things down. That's not the idea. A contract is going to be as complicated as the transaction it needs to express, and that can be plenty complicated, but nothing is gained by expressing that complexity in the mutant form of English that is traditional legalese. So, what do we do instead? Active drafting. We take control of our drafting by using standard English, following a set of guidelines, training people in drafting and reviewing consistent with those guidelines, and we express the deal clearly in a way that the parties can understand it without confusion. Well, you could say, oh, okay, great, that's easy, we'll do that then. Well, we have to do things to make that happen. And here's how I suggest we go about it. First off, adopt a style guide. Any kind of writing benefits from having a style guide, and given how limited and stylized contract language is and how high the stakes are, it's crazy that we've done without a style guide for so long. The idea is catching on. In particular, I note that last year, Adobe Corporation produced the Adobe Law Department Style Guide. It has some issues, and I wrote about it on my blog, but for my purposes, I think the most significant fact is that it exists at all. It says the idea is catching on. I wrote a manual style for contract drafting with the idea that it be the basis for an organization's contract drafting style, but the book's too unwieldy now. It's soon going to be 600 pages. You can't give all your contracts personnel a 600-page book and say, here, do this, which is why the plan is that next year the American Bar Association will publish my boiled-down version, kind of called Drafting Clearer Contracts. The idea, it'll just say, do this, don't do that. Provide a minimum of explication in a clear format. The idea is organizations can hand it out like party favors to their contracts personnel as a way of just ensuring greater consistency than would otherwise be the case. Then you train your personnel. I think the main point there is just to offer training in different media. The one interesting avenue that I'm going to be exploring next year is the idea of online certification to allow organizations to assess the extent to which training is actually worked. And also, I'm currently working on a new software called LexCheck, which there are quite a lot of products currently in the area of vetting draft contracts. Ours will look at mechanical stuff like, oh, did you define this term but not use it? But also it'll flag instances where the language doesn't comply with my guidelines. And an automated, the questionnaire for an automated contract template can also provide a good vehicle for training, but we'll look more at that in a moment. So, if you have a style guide, if you get trained and train your personnel, that's positive, but you also have to redo your templates because people draft by copying. And if all they have is dysfunctional templates, you can train them as much as you want, but they're still going to copy the dysfunctional language. You have to do the templates. That can sound like a large task, but it's not if you approach it sensibly and avoid drafting by committee where people sit around a table and debate based on imperfect information which of their pet contract usages are going to survive. Enlist serious expertise. Now, for smaller law firms, there's the challenge of economies of scale, because if an organization uses a template 800 times, it's going to make sense to invest resources in making that template as good as it can be. But while law firms, to begin with, have a challenge compared with companies because they tend to draft a broader range of documents and on an unpredictable basis, sort of depending on what business comes in the door. And with smaller law firms, those impediments are necessarily that much bigger. So there's been a certain theme to these sessions over these 2 days of specialization, and that's relevant here. If you want to capture economies of scale in this area, you have to specialize. I've heard tell of the notion that, hey, we can capture economies of scale in other ways, like by having people create optimal contract language online for free in a kind of utopian society. And I say, dream on. It's just due to some harsh economic realities, and when you know it, human nature, it ain't gonna happen. So maybe trade groups or vendors can capture economies of scale they can share with the rest of us. Why not? The big legal publishers or bar associations or Association of Corporate Counsel or trade groups for particular industries would be in a position to create automated templates, or just static templates, to be shared with their members or with others, with the payment being in the form of membership dues or just subscription fees. So that's the theory, but so far I have not seen any initiative that I can recommend to anyone. Various attempts, but they've all fallen short from my perspective. Indeed, it used to be something of a sport of mine to critique such initiatives, but it's kind of gotten to be kind of as much fun as shooting fish in a barrel. So somewhat reluctantly, my most recent entry into the fray was a few months ago, where I rolled out this guy, just to convey the point that, along with an analysis, critique on my blog, but just to make the point that if you want to serve a broader community by giving them templates. You can either do a half-assed job, or you can devote serious resources and serious expertise, because that's what's going to take to do a creditable job. Then there's automation. What do I mean by automation? Well, it's sort of like this, but a little different. You create contracts by answering an annotated online questionnaire. I think of it as templates on steroids, because that sort of automation allows you to build in customization of a sort that is inconceivable if you're doing the copy and paste thing. So for organizations, it's primarily a matter of asking themselves, okay, do we want to automate? Well, do we want to automate this particular contract? Well, how often do we use it in a year? What kind of, for deals of what kind of value? And what kind of customization do we need? So just after weighing those three factors, you do a cost-benefit analysis and decide accordingly. And once again, the issue of economies of scale is an issue for smaller law firms. And specialization is once again the key to whether you're able to do this. Again, there's the possibility of trade groups and vendors somehow being able to step into the breach and capture economies of scale for us. And again, here too, I haven't seen any initiatives where the technology used and the content are at a level that I could recommend. So there's the question of what do we, is there any possibility of something helpful being developed in that area? I think it needs two things. First of all, it needs someone to step up and fund the work necessary. It's not glamorous. It's not, it's a publishing venture at a time when the economics of legal publishing is, kind of perilous. And you also need, whoever funds the work also has to be able to kind of sell it to a broader market. Then secondly, the market needs to operate more rationally. The prevailing sentiment that as far as I've seen it, is, hey, why do I need to pay good money for a form of a contract when I can go to the great online rubbish dump and find something for free? So it's only when people are going to be willing to step up and pay for quality automated templates that something like that is going to happen. Hey, I'm happy to discuss the possibilities with anyone. To give you a sense of what quality contract automation might look like, I have some screenshots from an automated confidentiality agreement that I prepared a couple of years ago, lavishing vast amounts of time and energy on it. The idea is you have a questionnaire. This one uses Contract Express. There are various document automation tools out there. Contract Express is what's used by those organizations and law firms that are, have most invested in automated contract creation. It's a questionnaire of several pages. Each page has questions like, this one is about by what means a party can give notice to another party. Each question has guidance, like there and there, and it can have links to additional guidance if you don't want to clog up the questionnaire with a whole bunch of guidance. Now, in this question, email was given as the answer, but I just added the notice by FedEx would be suitable as well. And that caused the questionnaire to leap to life because it's a logic-driven questionnaire. It's not kind of fill in the blanks. If you change your answer to one of the questions, you can structure, whoever builds the questionnaire can say, okay, all right, you're interested in that issue? Okay, so we're going to ask you these extra questions. So you have a given answer can result in follow-up questions of this sort. And if you click on this link, it'll take you to this extra page, which itself can have further links buried in it. This question is about, okay, dispute resolution. Do you want the dispute resolution to cover provision to cover just contract claims or other kind of claims as well? Well, one issue about automated contract creation is that lawyers tend to be leery of the black box effect. I'm answering this questionnaire, and I get the draft that spits out at the end, but I don't have a clear connection between my answers and what's in the draft. Contract Express allows you to avoid that with the preview function. We click on preview, and we get where the focus is this question. All right, so we want it to cover all kinds of claims, and the preview mode will highlight language here. If you squint, you can see the grayed out language. Essentially, this is preview saying, if you answer if you give this answer to that question, this is the new language that we're inserting. So you get to see exactly what the connection is between your answer and what ends up in the draft. That offers greater security to the control freak drafters among us, and basically what that means pretty much everyone who works with contracts. And you can build in alerts like this. Oh, you selected California law as governing law, and you elected to have a waiver of jury trial. Well, guess what? They're not enforceable under California law. So you can build in alerts whenever a given answer conflicts with something else. And you can tie answers to outside databases, like depending on what state you choose, the user will be given an appropriate list of district courts to select. When you're done, you get a link to the final document, and out it comes as either a Word document or a PDF, as you choose. So this sort of automation makes my life vastly easier. Just in the past month, I've used it. I've gone through my questionnaire twice with consulting clients. Just, okay, we go through the questionnaire together, and when we're done, they have their draft. That's why I'm now kind of adding to my workforce to build a broader library of this kind of template for standard commercial contracts for use in my consulting work. Obstacles to this sort of approach? Well, people don't like change. What a shock. And it's not just us. I've encountered interesting discussions of just this kind of inertia, in medicine and even at restaurants. People like what they're used to, even if it doesn't work. So, and they're kind of sub-elements of the inertia, like, what you're telling me conflicts with my own view of my confidence after 25 years of doing this stuff, so I'm cheerfully going to ignore what you're telling me. I'm just going to block it out. Or, hey, yeah, what you're telling me makes sense, but everyone else does it a different way, and I'm going to have to stick with that. And I hear from people in M&A, for example, who say, yeah, it makes sense, but I can't be seen to rock the boat. And law firms themselves have additional obstacles to this sort of centralized initiative, fragmented power structure, and the billable hour itself is an obstacle to centralized initiatives. These are things we have to deal with if we're going to make progress. But a saving grace is that change in contract drafting isn't subject to a popular vote. You have to just convince people on your side of the table and people on the other side of the table. It's a private arrangement. So you don't have to wait for the world to change. You can go ahead and change your own private contracts ecosystem. It's the first step is deciding what you're more afraid of, change or the time and money you're wasting and the unnecessary risk that you're exposing clients to. And what the answer is will just depend on the circumstances. I see different organizations respond differently. But there's always going to be the issue of economies of scale. And there it's going to be a function of just well, you seeing what you can do on your own in terms of specialization, and seeing how rational the legal profession as a whole can be in terms of sparing us from having to reinvent the wheel endlessly. Because, hey, I'm second to no one in my love for contract drafting, but I recognize that that reinventing the wheel endlessly is not a good use of lawyer time. Helping with negotiation, devise strategy, research, that's a better use of your time. So we'll see, just the broader question is whether we can put things on a more sensible footing market-wide. Okay, we have 10 minutes for questions. If anyone has any, be delighted. Yeah.
What was the name of the service that you did your NDA with?
The software is called Contract Express. 2 words. My world was destabilized last year. Thomson Reuters acquired Contract Express. But hey, I do lots of stuff with Thomson Reuters too, so I feel right at home now. And I love Contract Express dearly. Yeah.
How do you balance legalese versus efficiency in language? Because you talk about both concepts, but the fact is that there's some legalese that we use that just reduces the number of words.
Okay. I'd rather not. I don't use the word legalese just because it's unclear. It can be a pejorative term, it's always bad, or it can just mean, hey, legal language. So I rather think in terms of art. There's some terms of art that are legitimate. I defy anyone to write a contract involving granting of security interest without using a term of art like security interest or perfecting. So some terms of art are unavoidable because it's a specialized kind of law we're dealing with. But I have looked at hundreds of words and phrases and combinations of them. It's a matter of kind of going through the trench warfare of just weeding out those that don't make sense. And there's a lot of them. Moral turpitude, one of the lamest phrases known to man. Coupled with an interest. What the heck does that mean? Yeah, okay, you can use it, but maybe you want to explain what the implications are. So there is no overarching answer. It's just a matter of you give me the word or phrase that's on your mind, and I'll tell you what I think, whether it's any use or not. My blog. I planted you to ask that question because my blog is just, it's been going strong for 10 years. And amazingly, I think I've kind of reached escape velocity or something. I just keep writing stuff. There ain't no end in sight. It's at adamsdrafting.com. And you all immediately flock there. That it's contract nerds welcome. Any other questions? Sure.
On one term about Latin, mutatis mutandis.
Oh yes, of course. Mutated, yeah. Hey, I don't know. My Latin ain't so hot. Mutatis mutandis. One simple rule is not because I'm some sort of plebeian, let's get rid of the Latin. With any adjustments, with such adjustments as are required, or something like that. In chapter 13 of my book, there's an entry, mutatis mutandis. Actually, maybe even on my blog, I don't know, where I just say, here's what I'd use instead. Well, with that, I believe, yeah?
I have a really old copy of your book that's nowhere near 600 pages.
Okay, what color is the cover?
Yellow.
The yellow. That's the first edition. The way it works is we have the current edition, which is fine. The previous version, which is, oh, it's an honorable effort. The version before that is, please pulp it, or just let's pretend it doesn't exist. So yes, the first edition was a good first attempt, shall we say. So yes, indeed. And so by the time the fourth edition comes out, the second edition will have assumed the role of embarrassment, and the first edition will just be something we don't speak about. So yes, I recommend that you run to Amazon post haste, and you'll be surprised at the difference the third edition makes. Yeah.
How do you recommend dealing with other parties who, particularly from big firms?
Yeah. Okay. All right. That's. Hey. Well, that ought to soak up our remaining time. Basically, yes. Some of what I suggest is kind of, hey, revolutionary, storm the barricades kind of stuff. But my book, I ain't no John Grisham, but my book has sold tens of thousands of copies. For a dull legal book, that ain't bad. And I think that indicates that the contracts world has deemed it a safe resource. But still, we're in a relentlessly precedent-driven corner of a conservative legal profession. So you can expect pushback. I recommend that the best way to handle that is to get your retaliation in first. Let the other side know what's going on. So on my blog and in my book, I have a little fantasy email cover note that says, this draft complies with the guidelines and manual style for contract drafting. Please don't waste your time and ours by trying to remake it as some piece of traditional contract drafting. I try and say it politely, and I know that I'll refine the language, and I might end up expanding it just because in my consulting work it's an issue that that my clients will be encountering. But I think if you let the other side know what's going on, you can mitigate the charming human urge to attack the unknown. Let the other side know what's going on, and there's a much better chance that they will react rationally. But that said, obviously there are some parts of the legal profession that are just particularly immune to change. But at the smaller law firm level, my sense is that folk are, everyone's more interested in just getting the deal done. So I think you'll get less of that irrational reaction. Yeah?
Do you have preferred sources for contract form?
Oh, excuse me. Excuse the instinctive reaction. Unfortunately, the answer is no. Because just what the efforts that have been produced thus far, I would not rely on. And I can't recommend that anyone rely on. That is just the sad fact. That's where it is a dreadfully inefficient market. Once upon a time, I had my confidentiality agreement out there, for free or close to it, but I ended up pulling it offline just because it's more valuable to me and my work. I would love dearly to be involved in some initiative that makes quality automated templates available to all. Hey, anyone have any great ideas? Have your people call my people. It's something I'll continue to work on. Work towards achieving. But for the moment, all I can do is just look out for myself and create what I can for my own use. Well, thank you very much, and there we are.